Now, you are to decide this case only from the evidence which was presented at this trial. The evidence consists of 1, the sworn testimony of the witnesses who have testified, both in person and by deposition. 2, the exhibits that were received and marked as evidence. And 3, any facts to which all the lawyers have agreed or stipulated to, and any other matters that have instructed you to consider as evidence. Now, what is meant by direct and circumstantial evidence? There are 2 kinds of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as a testimony of a witness about what that witness personally observed. Circumstantial evidence is indirect evidence that gives you clues about what happened. Circumstantial evidence is proof of a fact or a group of facts that causes you to conclude that another fact exists. It is for you to decide whether the fact has been proved by circumstantial evidence. If you base your decision upon circumstantial evidence, you must be convinced that the conclusion you reach is more probable than any other explanation. For example, if a witness testified that the witness saw it raining outside, that would be direct evidence that it was in fact raining. If a witness testified that the witness saw someone enter a room wearing a raincoat covered with drops of water and carrying a wet umbrella, that would be circumstantial evidence for which you conclude that it was raining. You are to consider both direct and circumstantial evidence. The law permits you to give equal weight to both, but it is for you to decide how much weight to give any evidence. In making your decision, you must consider all the evidence in light of reason, experience, and common sense. Although you must consider all the evidence, you're not required to accept all the evidence is true or accurate. You should not decide an issue by the simple process of counting the number of witnesses who have testified on each side. You must consider all of the evidence in the case. You may decide that the testimony of a fewer number of witnesses on one side is more or less convincing than the testimony of more witnesses on the other side.